Every night you worry that one simple mistake will steal your life's work from your children and hand it to complete strangers. Bureaucratic loopholes are stealing $58 billion from families just like yours every single year. I'm Samuel Montrose, CPA and attorney at law with over 35 years of experience, and I'm about to reveal the 6 legal mistakes that create pathways for strangers to claim your inheritance money. Strategy number 3 is the most dangerous. It hands your house directly to the state government, and 73% of Americans are making this mistake right now. Let's start with the most overlooked financial vulnerability that's draining money from families across America every single day. Strategy number 6, the beneficiary designation trap. Here's a financial predator that's hiding in plain sight, and it's not wearing a mask or using fake phone calls. This predator lives inside your own retirement accounts, life insurance policies, and investment portfolios. It's called the outdated beneficiary designation, and it's stealing money from families through a perfectly legal loophole that most people create by accident. Think about this for a moment. When did you last update the beneficiary information on your 401k, your life insurance policy, your IRA? If you're like most Americans, the answer is probably when I first opened the account, or I think sometime after my divorce. This casual approach to beneficiary designations is creating a massive wealth transfer crisis that's funneling billions of dollars to the wrong people. Here's how this financial predator operates. Every retirement account, life insurance policy, and investment account has something called a beneficiary designation form. This single piece of paper is more powerful than your will. It doesn't matter what your will says about who should inherit your 401k. It doesn't matter if you've told your children 1,000 times that they'll receive your life insurance money. The beneficiary form trumps everything else, every single time. The legal principle behind this is called transfer by contract. When you signed up for your 401k, you entered into a contract with the plan administrator. That contract says the money goes to whoever is listed on the beneficiary form, period. No judge can override it. No family member can contest it. The money flows directly to the designated person like water following the path of least resistance. Now here's where families are getting financially devastated. Let's say you got divorced 15 years ago and remarried 5 years later. Your current spouse is the love of your life, and your children from your first marriage are expecting to inherit your retirement savings. But buried in the paperwork at your old job is a beneficiary form with your ex-spouse's name on it. When you pass away, that $200,000 in your 401k goes straight to your ex-spouse. Your current family gets nothing from that account. Zero. This isn't a hypothetical scenario. Court records show this exact situation playing out in families across the country. In Pennsylvania, a man's ex-wife received $180,000 from his retirement account, even though they'd been divorced for over a decade. His children from his current marriage fought the case all the way to the state Supreme Court. They lost. The money went to the ex-wife because her name was still on a form he forgot to update. The financial damage goes beyond just the wrong person getting the money. These beneficiary designation mistakes often trigger family legal battles that consume thousands of dollars in attorney fees. Families spend more money fighting over who should have received the inheritance than they would have spent preventing the problem in the first place. But here's the part that should give you hope and relief. This is one of the easiest financial vulnerabilities to fix. You probably already have access to the solution right now. Most employers allow you to update beneficiary information online through their benefits portal. It takes less than 10 minutes, and it's completely free. The action step for maximum protection is simple but must be done systematically. Within the next 30 days, contact every single financial institution where you have accounts. This includes your employer's 401k plan, any old 401k accounts from previous jobs, all IRA accounts, life insurance policies, annuities, and investment accounts. Request the current beneficiary designation forms, review them carefully, and update them to reflect your current wishes. Make sure you're naming both primary and contingent beneficiary. The primary beneficiary gets the money first. The contingent beneficiary gets the money if the primary beneficiary has passed away. This creates a financial safety net that prevents the money from going into probate court if your first choice can't inherit. And here's a critical detail most people miss. Review these forms every time you have a major life change: marriage, divorce, birth of children or grandchildren, death of a beneficiary. Any of these events should trigger a beneficiary review. Set a reminder in your calendar to check these forms annually, just like you would schedule a medical checkup. The beauty of this strategy is that it works immediately. The moment you submit an updated beneficiary form, you've closed this legal loophole forever. Your money will flow exactly where you intend it to go, bypassing probate court and preventing family conflicts. While updated beneficiary forms are essential, they're just the first line of defense. The next vulnerability runs even deeper into the legal system, and it's costing families their financial independence when they need it most. Strategy number 5, the power of attorney evolution. The legal landscape of financial protection has undergone a radical transformation over the past 2 decades, and most families are still operating under outdated assumptions that could cost them their life savings. What I'm about to share with you represents one of the most significant shifts in estate planning law. Yet 70% of Americans are still following advice that was current in the 1990s. 25 years ago, attorneys routinely told clients that a simple will was sufficient protection for most families. The legal thinking was straightforward. If you became incapacitated, your family would petition the court for guardianship, and a judge would appoint someone to manage your finances. This process was seen as a reasonable safeguard against financial abuse. But here's what the legal evolution has revealed. This old approach is financially catastrophic. Modern case law shows that families without proper power of attorney documents are losing control of their finances to court-appointed strangers, and the legal costs are devastating. The breakthrough legal precedent came from a series of cases in the early 2000s where family members discovered they had no automatic right to manage an incapacitated relative's finances. Courts began appointing professional guardians, complete strangers, to take control of life-saving, sell family homes, and make financial decisions that benefited the guardian more than the family. Here's how this legal shift creates a financial nightmare. When you become incapacitated without a power of attorney, your family must petition the court for guardianship. This process typically costs between $15,000 and $25,000 in legal fees before anyone can even touch your bank accounts. The court then appoints a guardian who charges annual fees of 3–5% of your total assets to manage your money. Think about that mathematics for a moment. If you have $300,000 in assets, a court-appointed guardian will charge $9,000 to $15,000 every single year to manage money that your spouse or children could manage for free. Over 5 years of incapacity, that's $45,000 to $75,000 in unnecessary fees flowing to a stranger instead of protecting your family's financial security. But the cost goes beyond money. Professional guardians operate under court supervision, which means your family needs court approval for basic financial decisions. Want to sell the house to pay for better care? Court petition required. Need to access retirement funds for medical expenses? Another court hearing. These bureaucratic delays often prevent families from getting optimal care when time is critical. Now here's the part nobody expects. The simple legal document that prevents this entire financial disaster costs less than $500 to create and provides immediate, permanent protection. It's called a financial power of attorney, and it's the most underutilized wealth protection tool in America. A properly drafted financial power of attorney gives your chosen family member the legal authority to access bank accounts, manage investments, pay bills, and make financial decisions the moment you become incapacitated. There's no court involvement, no professional guardian fees, and no bureaucratic delays. Your family retains complete control of your financial life. The legal requirements for an effective financial power of attorney have evolved significantly. Modern documents must include specific language about digital assets, cryptocurrency, online banking access, and healthcare financing. They need to be durable, meaning they remain valid if you become incapacitated, and they should be immediate, meaning they take effect as soon as you sign them rather than waiting for incapacity. You also need a separate healthcare power of attorney that covers medical decisions. Financial institutions will not honor a healthcare power of attorney for banking transactions, and hospitals will not accept a financial power of attorney for medical decisions. You need both documents working together to create comprehensive protection. The legal precedent is crystal clear. Families with properly executed power of attorney documents maintain control of their finances during incapacity. Families without these documents lose control to the court system and professional guardians. The case law shows this pattern repeating in every state across the country. The action step is to schedule an appointment with an estate planning attorney within 60 days to draft both financial and healthcare power of attorney documents. Make sure the attorney specializes in elder law and includes modern language about digital assets and healthcare financing. The investment of a few $100s now prevents tens of thousands in court costs and guardian fees later. But even with power of attorney protection in place, there's a deeper legal vulnerability that most families never see coming. This next mistake doesn't just cost money, it completely rewrites who inherits your life's work. Strategy number 4, the intestacy inheritance hijacking. Last month, Margaret Chen walked into my office carrying a manila folder thick with legal documents and a story that perfectly illustrates how the legal system can betray families when they need protection most. Margaret was 67 years old, recently widowed, and discovering that her husband's failure to create a will had triggered a legal process that was about to give half of their life savings to his estranged brother, a man who hadn't spoken to the family in 15 years. Margaret's husband had always meant to create a will. They talked about it dozens of times over their 40-year marriage. He'd even researched attorneys and gathered financial documents. But like millions of Americans, he never took the final step of actually signing legal documents. When he passed away suddenly from a heart attack, Margaret assumed their jointly owned assets would simply transfer to her. She was about to learn how dramatically wrong that assumption was. What Margaret didn't know is that every state has a backup inheritance plan called intestacy laws that automatically kick in when someone dies without a valid will. These laws determine exactly who inherits your assets, and they follow a rigid formula that has nothing to do with your actual family relationships or personal wishes. In Margaret's state, the intestacy formula gave 50% of her husband's individual assets to his surviving spouse. That was Margaret, and 50% to his closest blood relative. Since her husband's parents had passed away, his estranged brother became entitled to inherit $180,000 from retirement accounts and investments that Margaret thought would help fund her retirement. The legal mechanism behind intestacy laws reveals just how dangerous this financial trap really is. When you die without a will, the state essentially writes your will for you using a one-size-fits-all formula. This formula prioritizes blood relationships over emotional relationships, legal marriage over long-term partnerships, and genetic connection over actual family bonds. Here's how these formulas typically work and why they're so devastating to real families. If you're married with children, your spouse might only inherit 1/3 to 1/2 of your assets, with the remainder going to your children. If you're married without children, your spouse shares the inheritance with your parents or siblings. If you're single with children, everything goes to the children equally, regardless of their ages, financial needs, or relationship with you. These rigid formulas create financial chaos because they ignore the complexity of modern families. They don't account for stepchildren you've raised as your own, children who are financially irresponsible, siblings you haven't spoken to in decades, or spouses who need 100% of the assets to maintain their standard of living. The case studies from probate courts across the country tell the same story repeatedly. In Texas, a woman's estate was split between her husband and her parents, forcing the sale of the family home to pay the parents their statutory share. In Florida, a man's assets were divided equally among 5 children, including a son with gambling addiction who spent his inheritance within 6 months. In California, a woman's estranged sister inherited 50% of her estate, despite 20 years of no contact. What makes intestacy laws particularly treacherous is that they vary significantly from state to state. If you move from one state to another, the inheritance formula changes automatically. Assets you thought would go to your spouse in Ohio might be split with your children in Florida. Property you assumed would stay in your nuclear family in Texas might be shared with your siblings in New York. The financial consequences extend beyond just who gets your money. Intestacy inheritance creates legal uncertainty that often triggers family conflicts and court battle. When distant relatives suddenly discover they're entitled to inherit assets, they often hire attorneys to claim their statutory share. These legal fights can consume 10–20% of the total estate value in attorney fees and court costs. Margaret's story had a devastating twist that illustrates just how far-reaching these laws can be. Her husband's brother hired an attorney and filed paperwork to claim his inheritance immediately. Because there was no will to provide clear direction, the estate had to go through formal probate proceedings that cost an additional $12,000 in court fees and legal expenses. Margaret ended up losing nearly $200,000 total, $180,000 to the estranged brother, and $20,000 in legal costs. The solution to prevent this inheritance hijacking is straightforward but requires immediate action. You need a legally valid will that explicitly states your inheritance wishes and supersedes the state's intestacy formulas. This document must be properly executed according to your state's legal requirements, which typically means signing in front of witnesses and having the signatures notarized. But here's the critical detail most people miss. Your will must be comprehensive enough to cover all your assets and specific enough to prevent legal challenges. Generic online wills often lack the detailed language needed to withstand scrutiny from disgruntled relatives or complex family situations. The action step for maximum protection is to work with an estate planning attorney to create a comprehensive will within 30 days. Make sure the will includes specific bequests for individual assets, clear language about who should inherit if your first choices predecease you, and explicit instructions about how to handle debts and final expenses. If you have a blended family, own business assets, or have family members with special needs, your will needs additional specialized language to prevent legal challenges and ensure your wishes are carried out exactly as intended. But creating a will, while essential, only solves part of the inheritance protection puzzle. The next legal vulnerability is actually built into the will process itself, and it's designed to transfer a significant portion of your wealth away from your family. Strategy number 3, the probate court wealth transfer system. You know that feeling when you suspect the financial system is rigged against ordinary families, when you sense there are legal loopholes that benefit professionals and bureaucrats while draining money from the people who actually earned it. Well, your instincts are absolutely correct, and I'm about to give you the proof you've been looking for. There's a court process called probate that's designed to transfer wealth away from grieving families and into the pockets of attorneys, court officials, and administrative bureaucrats. This system is so embedded in our legal structure that most people accept it as necessary and unavoidable. But the truth is, probate court is a wealth extraction mechanism that you can completely bypass with the right legal strategy. Here's how this legalized wealth transfer operates. When you die with a will, that document must go through probate court for validation. The court doesn't just rubber stamp your will and send your family on their way. Instead, probate triggers a months-long legal process where your estate pays fees to attorneys, court officials, appraisers, and administrators before your family receives a single dollar. The financial mathematics of probate are staggering. Court fees typically range from 2–4% of your total estate value. Attorney fees add another 3–7%. Administrative costs, appraisal fees, and other necessary expenses often push the total cost to 8–12% of everything you've worked your entire life to accumulate. Let's translate this into real numbers that hit families every day. If your estate is worth $500,000, which includes your home, retirement accounts, and life savings, probate will cost your family between $40,000 and $60,000 in fees before they inherit anything. That's a new car, a year of college tuition, or a significant portion of someone's retirement security that gets diverted to legal professionals instead of your loved ones. But the financial damage goes beyond just the fees. Probate is a public process, which means your family's financial information becomes part of the court record. Anyone can walk into the courthouse and review the details of your estate, creating privacy concerns and potential security risks. Predatory creditors, estranged relatives, and financial scammers often monitor probate records looking for vulnerable families with significant inheritances. The timeline makes the financial pain even worse. Probate typically takes 12–18 months to complete, and sometimes longer if there are any complications or disputes. During this entire period, your assets are frozen. Your family can't access bank accounts, sell investments, or use the money for immediate needs like mortgage payments or medical expenses. They're forced to fund their living expenses from other sources, while the probate court slowly processes paperwork. International legal practices offer a fascinating contrast that proves how unnecessary this wealth transfer really is. In countries like Canada and Australia, estates transfer directly to families through simplified administrative processes that cost a fraction of American probate fees. These systems prove that protecting inheritance rights doesn't require expensive court supervision and attorney involvement. The most revealing aspect of probate court is how it benefits everyone except the family. Attorneys earn substantial fees for routine paperwork. Court systems collect filing fees and administrative costs. Appraisers get paid to value assets. The only people who don't benefit financially from probate are the grieving family members who just want access to their inheritance. Here's the legal science that validates your suspicion about the system being rigged. Probate exists primarily to generate revenue for legal professionals and court systems, not to protect families. The asset protection and creditor notification justifications are largely ceremonial. The real purpose is creating a predictable income stream for probate attorneys and court bureaucrats. But here's what the legal establishment doesn't want you to know. You can completely eliminate probate court from your family's future using a legal strategy called a revocable living trust. This single document bypasses the entire probate system and allows your assets to transfer directly to your beneficiaries without court involvement, attorney fees, or administrative delays. A revocable living trust works by transferring ownership of your assets from your individual name to the trust during your lifetime. You serve as the trustee and maintain complete control over all decisions. When you pass away, a successor trustee you've chosen takes over and distributes the assets according to your instructions. No court involvement required. The financial benefits are immediate and substantial. Eliminating probate saves your family 8–12% of your estate value in fees and costs. Assets transfer to beneficiaries within weeks instead of months or years. Your family's financial information remains private instead of becoming public record. There are no court delays preventing access to needed funds. The action step for maximum protection is to establish a revocable living trust within 60 days and transfer ownership of your major assets into the trust. This includes real estate, investment accounts, bank accounts, and business interests. Work with an estate planning attorney who specializes in trust law to ensure the documents are properly drafted and the asset transfers are completed correctly. The initial cost of creating a trust typically ranges from $2,000 to $5,000, depending on the complexity of your situation. This represents a 90% savings compared to probate costs and provides permanent protection for your family's inheritance. Yet even families who successfully avoid probate through proper trust planning can still lose massive amounts of wealth to a different government agency that operates under its own set of confiscatory rules. Strategy number 2, the estate tax wealth confiscation. Picture this scenario 6 months from now. Your family has successfully implemented everything we've discussed so far. You've updated all beneficiary designations, executed power of attorney documents, created a comprehensive will, and established a revocable living trust to bypass probate court. Your inheritance plan seems bulletproof. Your loved ones will receive 100% of your life's work exactly as you intended. Then the IRS sends a bill for 40% of everything you've accumulated, forcing your family to sell the house you built, liquidate the investments you carefully selected, and drain the retirement accounts you spent decades funding, all to pay a tax bill that could have been legally eliminated with proper planning. This is the devastating reality of estate tax planning failures, and it's creating a massive wealth transfer from families to the federal government. The estate tax operates under a completely different set of rules than income tax or property tax, and most people don't realize they're vulnerable until it's too late to implement protective strategies. Here's how the estate tax system will work to confiscate your family's wealth. For 2024, the federal estate tax exemption is $13.61 million per person, or $27.22 million for married couples. This sounds like protection for only ultra-wealthy families, but there's a legal time bomb hidden in current law. These exemption amounts are scheduled to drop dramatically in 2026, potentially to as low as $6 million per person. The mathematics become terrifying when you calculate the true value of a typical family's accumulated wealth. Your $800,000 house, plus $600,000 in retirement accounts, plus $400,000 in life insurance, plus $300,000 in other investments equals $2.1 million in estate value. Add in future appreciation over 10-15 years, and many middle-class families will find themselves facing estate tax liability they never anticipated. But here's where the wealth confiscation becomes truly brutal. The estate tax rate jumps from 0 to 40% once you exceed the exemption amount. There's no gradual phase-in or progressive rate structure like income tax. You either owe nothing or you owe 40% of the excess amount. This creates a financial cliff that pushes families into forced asset liquidation. The real-world impact on families is financially devastating. IRS data shows that estate tax collections have increased by 23% over the past 5 years, as more families cross the threshold into taxable territory. These aren't millionaire hedge fund managers or tech billionaires. These are families who own small businesses, appreciated real estate, and saved diligently for retirement. The case studies from estate tax audits reveal how this wealth confiscation destroys family financial security. A family bakery in Ohio had to be sold to pay estate taxes when the founder passed away, eliminating jobs for 12 employees and destroying 3 generations of family business legacy. A ranch in Colorado was subdivided and sold to developers to generate cash for tax payments, permanently changing the character of a rural community. The cruelest aspect of estate tax planning failures is the timing. Families discover their tax liability when they're grieving and least capable of making complex financial decisions. The IRS demands payment within 9 months of death, creating enormous pressure to liquidate assets quickly rather than waiting for optimal market conditions. Professional tax data from estate planning attorneys shows a clear pattern. Families who implement estate tax reduction strategies maintain their wealth and pass it intact to the next generation. Families who ignore estate tax planning lose 25–40% of their accumulated wealth to government confiscation. But here's what should give you complete confidence and control over this situation. Estate tax liability is entirely voluntary. The tax code provides multiple legal strategies to reduce or eliminate estate taxes, and these strategies become more effective the earlier you implement them. The most powerful approach is lifetime gifting using the annual gift tax exclusion. For 2024, you can give $18,000 per person per year to as many people as you want without triggering any tax consequences. A married couple can give $36,000 per person per year. Over time, these gifts remove assets from your taxable estate while allowing you to see your beneficiaries enjoy the money during your lifetime. Advanced strategies include charitable remainder trusts, grantor retained annuity trusts, and family-limited partnerships. These legal structures can reduce estate tax liability by 50–80% while providing ongoing income and maintaining family control over assets. Life insurance planning offers another powerful estate tax solution. Properly structured life insurance policies can provide tax-free death benefits to pay estate taxes, allowing families to keep all their other assets intact. The insurance proceeds replace the wealth that would otherwise be lost to taxation. The action step for maximum protection is to consult with a tax professional who specializes in estate tax planning within 90 days. Request a comprehensive analysis of your potential estate tax liability under current law and projected law changes. Develop a specific implementation plan for the reduction strategies that fit your family situation and financial goals. The investment in professional estate tax planning typically ranges from $5,000 to $15,000, depending on the complexity of the strategies involved. This represents a 95% savings compared to paying estate taxes and provides permanent protection for your family's accumulated wealth. You now have the legal knowledge and practical strategies to protect your inheritance from beneficiary designation mistakes, court-appointed guardians, intestacy formulas, probate court fees, and estate tax confiscation. But there's one final legal trap that's even more dangerous than all these individual vulnerabilities combined. So here's what I need you to understand. The financial predators we've exposed today aren't just random scammers or distant relatives looking for a quick payday. You're fighting against a systematic legal framework designed to transfer your wealth away from your family. You're battling bureaucratic loopholes that benefit attorneys, court officials, and government agencies, while your loved ones struggle to access the inheritance you worked decades to build. But you are not powerless in this fight, because now we reach the most devastating wealth destroyer of all, strategy number 1, the coordination gap. This is when your retirement accounts say one thing, your life insurance policies say another, your will says something completely different, and your trust documents contradict all of them. When these legal documents don't work together, they create a legal nightmare that can consume your entire estate in attorney fees, while your family fights for years in multiple court systems. Legal precedent shows us million-dollar estates that have completely disappeared into legal costs because families had 5 different documents pointing in 5 different directions. The attorneys get rich, the courts collect their fees, and the family gets nothing but bills and heartbreak. You now have an arsenal of 6 legal shields to protect your family's financial future. The beneficiary designation review that ensures your retirement money flows directly to your chosen family members. The power of attorney protection that keeps court-appointed strangers away from your finances. The comprehensive will strategy that overrides state inheritance formulas. The revocable living trust that bypasses probate court entirely. The estate tax planning that prevents government confiscation of 40% of your wealth. And the document coordination system that ensures all your legal protection works together seamlessly. Now I want to hear from you in the comments below. Which of these 6 strategies shocked you the most? Do you have your own story about family members fighting over inheritance or watching strangers legally steal money that should have stayed in the family? What's your biggest fear when it comes to protecting your life's work for the people you love? Drop your experience in the comments. Your story could be the wake-up call that protects someone else's family from financial devastation. If this video opened your eyes to how strangers can legally steal your money through bureaucratic loopholes, you need to hit that subscribe button right now. Every week, we release new videos packed with legal strategies to help you stay financially secure, protect your wealth from government confiscation, and ensure your family inherits every dollar you've earned. Next week, I'm revealing the 3 simple legal documents that can bulletproof your estate from family members who might contest your will, including the one document that makes your wishes legally unbreakable. You are only one smart decision away from complete financial protection.